Okay, good morning, everyone. This is Dr. Sumit Pahwa, and thank you, audience. Thank you, everyone, for joining in great numbers. And the fact that you have joined in such good numbers is demonstrative of the fact that how important the topic is, code on wages, and in fact, all the labor codes. Joining me is Surbi. Hi, Surbi. Good morning.
Hi, Dr. Sumit. Good morning.
Yes. Okay, so I'll offer a brief introduction. First about myself, I'll give a quick introduction and then about the speaker. So I'm Dr. Sumit Pahwa, corporate lawyer, company secretary, 25 years of experience in legal and compliance domains. I'm currently the co-founder and CEO of Complinity Technologies, which is India's leading compliance software, helping more than 350 companies comply with the 3,000 plus laws with a checklist of 40,000 plus compliances. In fact, 350 plus unique corporate groups comprising 1,500 plus companies of the likes of Panasonic, Max Hospital, Oberoi, Toyota, Yes Bank, British Council, and many more. Uh, and joining me is Surbi Kohli. Surbi is a principal associate at eMinds Legal. eMinds Legal is a boutique corporate law firm specializing in corporate secretarial, corporate legal, and compliances and accounting, tax, and payroll. And Surbi is a principal associate with a master's degree in corporate law with over 10 years of professional experience. She's a corporate lawyer specializing in advisory, contract drafting, labor and employment laws, compliance audits, IPR, trademarks, copyrights, etc. And she has extensive experience in advising clients on labor codes, employment matters, data privacy laws, legal due diligence, drafting of transaction documents, investment documents, complex regulatory compliance requirements, issues, audits, etc. So welcome, Surbi, to the webinar.
Thank you, Dr. Sumit.
Yes. Okay, so now about the topic. In fact, we are well aware of the topic. The topic has been here since 2019. The Code on Wages is one of the most significant reforms in India's labor law landscape aimed at consolidating and simplifying wage-related regulations. In fact, all the four codes, but today we'll be talking of Code on Wages. A key feature, as you may have noticed, is the introduction of uniform definition of wages, which has far-reaching implications on compensation structures, payroll practices, statutory benefit calculations like PF, gratuity, bonus, etc. Organizations must evaluate their existing salary structures and compliance processes to ensure readiness with a new regulatory framework. So today's session, we bring insights from Surbi, who's a labor law expert, and she'll be touching upon the overview of the Code on Wages, the understanding of the revised definition of wages, what is the compliance impact on the organization's salary structuring, payrolls, impact on PF, gratuity, bonus, etc. Talking about floor wages, minimum wages, etc. Best practices, gray areas, implementation challenges, and Q&A. This is what will be covered. What will not be covered is the other three codes. We could have done one webinar on all the four codes. However, we wouldn't be doing justice to the topic because each of the codes is a very deep dive topic. So we thought we'll do deep dive at least 1 hour sessions on each code. So starting with Code on Wages today, and very soon in the next few weeks or months, we'll be doing the other three codes also. So today we will not be covering IR code, the Industrial Relation Code, Code on Social Security, Occupational Health, Safety, Health and Working Conditions Code, but we'll be focusing on Code of Wages. So the format is like this, is 12:09. We'll start in a couple of minutes. And Surbi will take about an hour, 50 minutes to an hour for her presentation on the Code of Wages, which is very detailed presentation. In the meantime, you can keep on recording your Q&A in the Q&A box at the bottom. And towards the end, last 20 minutes or so, we'll take all the Q&A and try to see. And if the Q&A pertains to the other codes, she may answer it, she may defer it. But on the Code of Wages, we'll be happy to answer all the Q&A today. Okay, so you can follow us on our channels, YouTube, LinkedIn. You can request a demo for Complinity. The links will be there in the chat box. You can connect with me also on my LinkedIn. My link will also be there. I keep writing about, I'm a PhD also in emotional intelligence, and I keep writing about articles on emotional intelligence and leadership. Just before we start, I'll run a very quick poll just to know you slightly better. 1 second, and then we start. Yes. Okay, so here goes the poll. Please identify yourself. Are you a practicing professional or a consultant? Are you a general counsel or a legal team? Are you CFO, finance team, tax team, HR, or in-house company secretary, compliance professional, or others? This will help the speaker know the audience slightly better, and she can customize her presentation or the delivery of the speech accordingly. So I'll wait for 10 more seconds. If you can quickly choose who you are, what describes you best. And as you're filling this, a recording of this webinar will also be up on the YouTube channel in a few days. But and we'll finish in 90 minutes. So if you're here till the end, you'll be seeing the live at least FAQs. There are a lot of FAQs which come up in our earlier experience, and they're very nice questions. So keep throwing your questions, and you'll be sort of seeing the speaker answer those questions as well. Okay, so here I end the poll. Or I'll wait 5 more seconds. If you can quickly answer. Surbi, is my voice clear?
Yes.
Okay. Because the Zoom is telling me that my voice is echoing, but then if you are saying it's clear, then it's clear. Yeah. I'll rely on the human intelligence, more than the artificial intelligence. Okay. So I'll end the poll and share the results. So 20% practicing professionals consultants, 11% GC legal team, 11% finance team, 30% HR, 17% company secretary. It's a mixed bag, Surbi. I think you imagine 20% in each bucket, and that's what broadly it is. Right?
Yes.
Okay. So with this, we start with the webinar. Surbi, you can share your screen and start with the webinar.
So thank you, Dr. Sumit, for the kind introduction. And good afternoon, everyone joining us today. First of all, I would like to thank eMinds Legal and Complinity Technologies for coming together and to organize this webinar and create a platform to discuss one of the most significant labor law reforms in India, that is the Code on Wages. I'll just share my screen once. Yeah. So is the screen visible,
Yeah,
Dr.
visible.
Sumit?
Visible. Yeah, visible.
So, so sorry. Yeah. So while the code has been in existence for several years now, all of us know that many of the HR professionals, employees, and employers do have questions about the practical implementation of the codes. And that's because the codes have just come into existence. And it is, a lot of questions are there. What is applicable? How is it applicable? State rules are not yet notified. So that's why the code on wages becomes a very important topic to be discussed today. Over the next 60 minutes, I'll be discussing the key provisions of the code and what all practical challenges do we face and how do we implement those in the industry. So, with that, let's begin with the code on wages understanding. Why did this code came into existence? So, when we think why was the code needed, let's imagine there are two employees in an organization, in the same organization, with the CTC of 1 lakh rupees. One of them is getting good PF, higher statutory contributions, and higher gratuity. The only reason for that is the salary structuring. The salary structuring of both the employees is different. Why that is the reason why one person is getting greater statutory benefits and the other is not getting the statutory benefits. This was the reason why code came into picture because code wanted to ensure that there is uniformity, there is fairness, and the salary structuring is done in such a way that the allowances are not more than what is there as the basic pay. After understanding the reason why code on wages implemented, first we need to understand what is the background. When did this code came into existence and what is the present status of the central rules and the state rules. Before that, it is also important to know that what are the four acts
So
that.
if I may just interrupt,
Yeah.
certain people are saying that our voice is echoing. We have enabled the chat box. Can you just confirm, audience, is the voice clear or is it echoing in the chat box, not in the Q&A box, in the chat box? Okay. Okay, so many people are saying it's clear. Some people are saying it's echoing. Okay,
Yeah.
so okay, many I think 80-90% it's fine. So for the people for whom it is echoing, if you can just log out and log in once more, maybe, or try another system, because we tried from our side, it's clear on many systems, but in one or two systems we also found it's echoing. So for the ones it's echoing, if you can retry, maybe log out, log in, or try a different system or mobile phone, etc. I think that's the only thing we can suggest, because everything is fine from our end. It looks like a Zoom or a technical issue. But 80-90% it's clear, so we'll continue. Yeah, so be sorry for the disturbance. You can continue. Yeah.
That's okay. All right. So the four major acts that merged into Code on Wages are Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. These are the four acts that now have been repealed, and those have been subsumed in Code on Wages. The acts were majorly for timely payment of wages, fixation of minimum wages, compulsory payment of bonus, and the equal pay for equal work. Now, because the state rules are not yet notified fully for all the states, as per the provisions of Section 6 of the General Clauses Act, old rules will remain in force till final notification of new rules under the code, to the extent those are in lines with the code. So this is something that we need to actually keep in consideration when it comes to our mind that, okay, because the central rules are there, certain states have also started implementing, what is the next step that we should be doing? So till the time all the rules are not there, we can wait, and the previous acts and the previous rules will be there in picture. Now, coming to the background and timeline, what is the background? When did this code on wages came into existence? It was on August 8, 2019, when the code on wages received presidential assent, and it was notified as the code on wages 2019. On December 18, 2020, partial provisions came into force. On November 21st, 2025, majority of the provisions were formally brought into force by official gazette notification. On December 30th, 2025, draft code on wage central rules were published in the Gazette of India, which were open for invitation by the stakeholders to submit their objections and suggestions. It was in May 8, 2026, when the code on wages central rules were officially notified by the Ministry of Labour and Employment. Now, this was the status of central rules. Coming on to the state rules, it as on date, today, only Arunachal Pradesh, Bihar, Gujarat, Punjab, and Sikkim are the states that have formally notified their respective rules under the Code on Wages 2019. The rest of the states have published their draft rules under the Code on Wages, which is open for consultation and feedback. Only West Bengal is the state that has neither notified its rule nor released the draft rules under the Code on Wages. So this was the status of the state rules. With that background, let's discuss what is the applicability of the Code on Wages. Now, the Code on Wages is the act which is applicable to the whole of India. It applies to all the employees and applicable to all the establishments without any sectoral exclusions. It is there on central government and the state government employees as well. So that's the applicability of the Code on Wages. With the applicability, we would be now moving forward with the key changes that are introduced in the Code on Wages. First, the main heart of the Code on Wages is definition of wages. In the earlier regime, under various acts like Minimum Wages Act, Payment of Wages Act, there were different definitions across the acts. But now, Code on Wages has single uniform definition of wages across all establishments for all the employees. Next, 50% of wage rule. There is no uniform statutory ceiling on wage structure, which was earlier there in the previous regime, but now the new code says at least 50% of the total remuneration to be treated as wages. So these are the key changes that we're discussing in nutshell right now. We will be discussing these in details in the coming slides. Third, digital compliance. Mostly manual registers and filings were there, but now electronic maintenance of records, registers, and returns are permitted. Coming to the definition, earlier the term contractor was very often used in all these acts, but there was no uniform definition under the wage laws. But in the Code of Wages 2019, there is express definition of contractor, which includes labor suppliers, service providers, and subcontractors, and excludes the contractors who are only in the business of supplying goods. So those are not included in the definition of contractors. The very next important key change brought under the Code on Wages is full and final settlement timeline. So in the earlier acts, except for the termination, there was no prescribed timeline for resignation, retirement, removal, or the payment to the employee after the closure of an establishment. But now Code on Wages uniformly make it applicable for all the modes of separation for employees, that you have to make payment within 2 working days, including events of removal, dismissal, retrenchment, unemployed due to closure, termination, as well as resignation, which was not there in the earlier act. However, it is worthy to note that State Shops and Establishment Act still prevail. Now, why it is important? Because the code specifically mentions if there is any other law in existence that provides a similar timeline, that will prevail. Let's take an example of Punjab State and Establishment Act, which is applicable on the state of Haryana and the state of Punjab. In the Punjab State and Establishment Shops and Establishment Act, it mentions that for resignation, if an employee resigns, you have to make payment within 30 days. That is the pay cycle. Pay cycle is for 30 days period. And in case of termination, you have to make payment within 2 working days. Now, the code says that 2 working days is there for all the situations. But because the Shops and Establishment Act mentions for resignation, you have 30 days time, so that will prevail. Irrespective of the code mentioning that there are 2 working days in case of resignation for Punjab and Haryana, you have 30 days time period to make payment of the full and final settlement timeline. So that's why it becomes very important to refer the respective states, Shops and Establishment Act while deciding the full and final settlement timeline. Registers and forms. Earlier, there were multiple forms under the different acts. It was actually very cumbersome for the employers to ensure that for each of the 4 acts and many other acts which are there in the other codes, for every act, you had certain registers, certain forms which had to be maintained quarterly, annually, half yearly. But now, Code on Wages has unified and simplified these registers, wage slips, and the returns which are prescribed under the rules. Authority for wage claims. There were multiple authorities earlier, but now the appropriate government, that is either the state government or the central government, will by notification appoint one or more authorities which are not below the rank of a gazetted officer to hear and determine the claims. For the inspection system, physical inspections with limited transparency was there earlier. But now a new position, that is Inspector-cum-facilitator model, with web-based, randomized, and transparent inspections will be there under the Code on Wages. After understanding the key changes that have been introduced in the codes, let's dive deeper into the same. And the main question that comes after hearing the Code on Wages is what is going to happen with the wages? Because everywhere we see 50% wage rule is there, but that's very difficult to understand what exactly is that 50% rule. So before we understand the impact of the new definition of wages, it is important for us to understand what is the definition of wages. Now, let's imagine the salary slip that we have in our hand every month. We see that there are a lot of components on the salary slip, which includes basic pay, HRA, conveyance allowance, other allowances. So these all components are there in the salary slip. But the code says that all components are not same, because the wages is further bifurcated into 2 parts. One is inclusions and the other one is exclusions. In the inclusions, there are 3 main parts. First is basic pay, second is durance allowance, and the third is retaining allowance. These 3 are the only components that forms the inclusions of the wages, that forms a part of wages. The rest of the parts which is there is the exclusions from wages, which is first any bonus that is payable under any law, that is statutory bonus, and not a bonus that forms a part of the remuneration payable as per the appointment letter or the terms of employment. Second, value of any house accommodation or supply of any water, medical, attendance, or any other amenity as may be excluded by government order. Third is the employer's contribution to any pension or provident fund. That employer's contribution is also there in the salary slip, but that is excluded from the definition of wages. Fourth, conveyance allowance or any value of traveling concession. Fifth, sums paid to special expenses for if there is any special expense because of your employment nature, that is also excluded from the definition of wages. House rent allowance, then the remuneration payable under any award or settlement between the parties, any overtime allowance, any commission payable to an employee, and including any gratuity and any retrenchment. All these 11 components are excluded from the wages, and the only thing that is included is basic, dearness, and retaining allowance. Now, there's also an explanation to Section 2Y, which says where an employee is given in lieu of the whole or part of the wages payable to him, any remuneration in kind, the value of such remuneration, which does not exceed 15% of the total wages payable to him, shall also be deemed to form part of such wages. So, wages means the remuneration which is ordinarily payable to the work done under the terms of employment, and it is subject to the inclusions and exclusions mentioned there. With that, now let's understand what is the 50% wage rule. Let's consider of an example. Is it possible that your basic pay is 30,000 per rupees, whereas 30,000 per month, whereas your components, other components, including allowances, HRA, forms 80% of the remuneration? Yes, it was earlier possible. But now, with the Code on Wages, this is not possible. Code on Wages mentions if your inclusions and exclusions both form the part of remuneration, your inclusions cannot be less than 50% of your total remuneration. Let's think of a pizza. So, pizza, the law says the pizza base, that forms the basic pay, DA, and retention allowance. And the toppings on top of it, HRA allowances, conveyance allowance, special allowance, those forms the exclusions which are generally excluded. But now, if your toppings becomes too much and the base becomes too small, code says that you will have to treat toppings as a part of the base. That's the 50% rule. For the purpose of calculating statutory benefits also, wages must constitute at least 50% of employees' total remuneration, that is your CTC. Where excluded components exceed 50% of the total remuneration, the excess amount will be added back to the wages. This example that we have on the slide, we see that basic pay is 30,000, fairness allowance is 5,000. So the inclusions are 35,000. Total remuneration is 1 lakh rupees. So 35,000 out of 1 lakh rupees forms only 35% of the remuneration. To comply with this 50% wage rule, it is important that the shortfall, which is 15,000 from the excluded allowances, will be added back to the wages. So now the wages will be 50,000 for the purpose of statutory calculations. This is the main 50% rule that has been introduced in the Code on Wages. Now, what is the implication of the definition of wages that practically is getting difficult, or how is that practically implicated on the industry? First, higher wage components may result in increased liabilities towards gratuity, retrenchment compensations, layoff compensation, and other wage-based benefits, because all of these are calculated on a basic pay, that is basic DA and retention allowance. Employers may now need to review and redesign the existing salary structures to comply with this 50% wage rule. An increase in the wage component can lead to higher overall employment cost for employers due to increased statutory benefits obligations. The code now restricts the practice of minimizing the wage component by allocating a substantial portion of remuneration to allowances, other excluded components, thereby promoting greater protection of employees' statutory benefits and social security entitlements. Coming on to the definitions, so there are a lot of definitions which have now been introduced in the codes, and some of the definitions which were earlier there in all the 4 acts, and there were different definitions, which are now made as a unified definition for that particular term. The major definitions which is there in the code is employee and the worker's definition. Coming to the employee's definition is a very wide definition. Earlier, it was as an employed person under the Payment of Wages Act, as an employee under Minimum Wages Act, for the employments that were there in the schedule. In the Payment of Bonus Act, employee again has a different definition, where the employed person, if the person is employed on a salary not exceeding 21,000, then he was considered as an employee. But in the new definition, employee means any person other than an apprentice and any member of the armed forces. These are the only two exceptions which are there, which is there in the employee, the apprentice and the armed forces. Besides these two persons, any person which is employed on wages by an establishment to do any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, any kind of work for hire or reward, whether your terms of employment are express or implied. It also includes a person declared to be an employee by the appropriate government, but excludes any member of the armed forces. So what has changed? Now the employee includes every person employed irrespective of the salary, including supervisory, managerial, and administrative person. So this was the broad definition, which includes every person. Now there is next definition, which is workers definition. Workers definition as compared to the employee is a narrow definition. It was not defined earlier in Payment of Wages Act, Minimum Wages Act, or the Bonus Act. It was only there in the Equal Remuneration Act. Now, the workers' definition includes out of these four acts. Of course, it was there in the other acts like ID Act, but Industrial Disputes Act. But in the Code on Wages, worker is defined as any person employed to do any manual, unskilled, skilled, technical, operational work, including working journalist or sales promotion employees, persons dismissed, terminated or discharged due to dispute, but it excludes apprentices who are trainees, persons subject to the armed forces, police staff, prison staff, managerial and administrative staff, or any person employed in a supervisory capacity earning more than 18,000 per month. So besides these exceptions, all other people are there considered as a worker. So now we can say that every worker is an employee, but all employees are not a worker. All employees are not a worker. Now what has changed? Introduce a unified definition of worker under the codes, which was not there earlier in the four acts that have been repealed. The next definition is employer. Payment of Wages Act had a different definition, Equal Remuneration Act, Minimum Wages Act, Payment of Bonus Act. All the four acts had different definitions. But the code says employer includes any person employing one or more employees directly or indirectly, and includes the head of a government department, the chief executive of a local authority, a factory occupier or manager, any person having ultimate control over an establishment, including a manager or a managing director, a contractor, and even a legal representative of a deceased employer. So what has changed now? Besides single unified definition, now the definition of employer explicitly includes indirect employment relationships, contractors, and even the legal representatives of a deceased employer. So this is the new definition of employer, which is there in the code. The next definition is establishment. In the new codes, establishment means any place, not a building, not a confined four walls area, but a place where any industry, trade, business, manufacture, or occupation is carried on and includes a government establishment. So now the code has merged multiple sector-specific definitions into one broad definition and centrally governed definition of an establishment. The term contractor, we have read the term contractor used very often in the four acts, but it was nowhere defined in these acts. But the new definition in the new code says contractor means a person who, in relation to an establishment, it is important to note contractor has to be related to in relation to an establishment, either undertakes to produce a given result for the establishment through contract labor, or supplies contract labor for any work of the establishment as human resources, and includes a subcontractor as well. There is one exception to this definition, which mentions other than a mere supply of goods and articles. So if a contractor is just into the business of supplying a particular good or an article to an establishment through its resources, then that person is not considered as a contractor. Contractor must be in relation to an establishment supplying contract labor for any work of the establishment and includes a subcontractor as well. Now, again, Just like contractor, there's a new definition of contract labor, which was not clearly defined earlier in the 3 acts. Contract labor means any worker deemed to be employed in or in connection with the work of an establishment when hired through a contractor. That contract labor must be hired through a contractor with or without the knowledge of the principal employers and includes an interstate migrant worker. But it excludes a worker who is regularly employed by the employed government with periodic increments, social security coverage. So any person who is employed in an establishment through a contractor is a contract labor, but it excludes the regularly employed persons by a contractor.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Now, if a contractor has its employees who are working with him on a daily basis for the contractor and those are then supplied to the industry, to any other establishment, that is not a contract labor. Contract labor is which is solely hired to an establishment through a contractor. Wages, just like we discussed, wages means all remunerations and includes only basic salary, DA and retention allowance and excludes all other exclusions that we just now discussed. What has changed? A unified wage definition including only basic pay, dearness allowance and retention allowance. Or other allowances including your employer contribution to Provident Fund or pensions, house rent allowance, remuneration under any award, all of these are excluded and only basic pay, DA and retention allowance forms a part of wages. There is also a concept of same work or work of similar nature, which was earlier there in the Equal Remuneration Act. Now, the same has been included in the Code of Wages also, with a change that the same has been made gender neutral and added experience as an additional criteria for determining whether the work is the same or of a similar nature. So, this is the change that is there in the same work or a work of similar nature. After understanding the definitions, the very important concept in the course is also about the appropriate government, which forms a very important role because appropriate government is further divided into state government and the central government. For the purpose of appropriate governments, central government is the appropriate government for establishments carried on by or under its authorities, including railways, mines, oil fields, major ports, air transport services, telecommunication services, banking institutions, and insurance companies. It also includes central public sector undertakings, its subsidiary companies and autonomous bodies, which are ultimately owned or controlled by the central government. Not even these. When the contractors are engaged for the purpose of the central government establishments, even though for those contractors, central government remains the appropriate government. So it is a possibility that the contractor has a private establishment. But if it is engaged in the purpose of providing contract labor to the central government establishment, the central government remains the appropriate government for those contractors. For every establishment not falling in the above categories, the state government is the appropriate government. And the most private sector establishments are now governed by the state government unless they belong to a category which is specifically assigned to a central government under the code. Having said that, now when we hear that the rules are out, so rules are out for the central rules, which are fully notified now. For the other states, only besides leaving 5 or 6 states that I just named, rest of the states' rules are still on the draft stage. So the codes cannot be fully implemented on those establishments unless those rules are out, because the registers and several other provisions are now decided by the appropriate government. So the central rules are only applicable on the central government, which is mentioned in the above 3 points. Only the state government is there for the private sector establishment. The concept of minimum wage is introduced under Section 5 of the codes, which says that no employer shall pay to any employee wages which is less than the minimum rate of wages notified by the appropriate government. Now, the minimum wages shall be notified by each state government. The state government shall fix minimum wages for both time work and piece work. It will be mentioning wages for the people who are working based on time and the employees who are working on a piece rate basis. For employees engaged on a piece rate, a minimum wage on a time work basis shall also be prescribed to ensure that at least a minimum level of earnings are there for the employees. Minimum wages will be fixed on an hourly, daily, or monthly basis also, and wages shall be calculated in the manner prescribed depending on the applicable wage period. Minimum rates are also fixed based on skill level. Now you'll have notification where unskilled to highly skilled levels, including geography, plus factors like work arduousness, temperature, humidity, hazardousness, all these will be considered by the state government while fixing minimum wage. Now, this minimum wage concept is based on another important concept, which is further we would be mentioning in the slides, that's the floor wage. But before we jump onto that, there's few other points that we need to consider, that the state government shall be formulating committees, and that committees will be comprising of the representatives of the employers and the employees in equal numbers. These wages will be fixed or revised by the government. And it is important that once we have this notification, we will have 3 months time to take that effect. So it is not that today we are having the notification, we'll have to bring that into effect from tomorrow. We have 3 months time period after every notification, unless it is specified in the notification itself, that we'll have to make that applicable from the very next day. Appropriate government shall review the wages at an intervals not exceeding 5 years. So even after 1 year, 2 years, 3 years, the state government has the right to revise the minimum wages. Section 9 of the Code on Wages mentions floor wage. Now, the concept of floor wage is like a foundation of a building, a foundation of a house. Let's consider floor wage as the foundation of the house, and the minimum wage is the building. Just like a building cannot go beyond your foundation, then the minimum wages also cannot go below your floor wage. So the central government is the appropriate government who will be fixing the floor wage after consulting with the Central Advisory Board and considering minimum living standards like food, clothing, geographical areas. Input from the state government will also be sought, so that those are also considered before finalizing the floor wage. And minimum wages fixed by the appropriate government shall not be less than the floor wage, where existing minimum wages are higher than the floor wage, they shall not be reduced. This is a very important concept. So if we see that the minimum wages which are already existing are higher than the floor wage, they will not be reduced by the state governments. This ensures a balanced approach by incorporating both central and the state perspectives. Now, with respect to this minimum wage, there are minimum wage entitlements for partial work and multiple job roles. This is a concept which is there in codes, which says if an employee has worked for less than a normal working days, he will be entitled to wages as if he has worked for the full normal working day, unless the shortfall is due to his unwillingness to work. So if the employee is willing to work for the entire day, but he worked for not for 8 hours or 9 hours, he worked for 5 hours in a day, then he will be entitled to a full normal working day wages. These full day wages shall not be payable whether the employee fails to work due to his unwillingness or other prescribed circumstances. Similarly, wages for multiple classes of work is mentioned under Section 11 of the Code. Now, let's assume an employee is performing a work in an organization in both skilled and unskilled categories. During the 8-hour periods in a day, for 4 hours he worked for a skilled work, and for 4 hours he worked for unskilled work. Now, for skilled work, if the minimum wages is 5,000 And for an unskilled work, if the minimum wages are 3,000, employee would be getting a mix of both because he worked for both skilled and unskilled job. So it would be 2,250 for skilled job and 1,500 for an unskilled job. His total wages would be minimum would be 4,000. So that's how wages for multiple classes of work has been introduced in the. So when an employee performs 2 or more types of work with different minimum wages rates, wages must be paid separately for each type of work. For each class of work performed, the employee shall be paid not less than the applicable minimum rate for the time spent on that. Moving on to working hours and the overtime conditions. While fixing minimum wages, the appropriate government may fix the number of hours which are constituting a normal working day, intervals for rest, 1 day of rest in every 7-day period, payment of work on a rest day. So the government has the right, state government or the central government, to fix any of these, which it may or may not decide to fix. Wages for overtime work, employees working beyond normal working hours shall be entitled to overtime pay at a rate of at least twice the normal wages for each hour or part thereof worked as an overtime. Moving on to mode of wage payment. Earlier under the Payment of Wages Act, it was mentioned that the wage payment can be made in the coin or currency or check plus bank credit. Now, the new provision has been included in the codes, which mentions payment methods includes every mode almost, because these acts were there in 19th century. At that time, there was no digital compliances which were there. There was no digital payment there as well. So now payment methods includes coin, currency, check, bank credit, or electronic mode as well. So, and for notified establishments, the wages shall be paid by either check or bank credit only. That is for the notified establishments by the appropriate government. Rest, it can be made to an electronic mode as well. Fixation of wage period, which is mentioned under section 16 of the code. Earlier, employers had to fix wage periods wherein no wage period should exceed 1 month. The new provision says the employer shall fix the wage period for employees either as daily or weekly or fortnightly or monthly, subject to the condition that no wage period in respect of any employee shall be more than a month. With the fixation of wage period, it is also important to understand what is the time limit for payment of wages. So the code says the employer shall pay or cause to be paid wages to the employees engaged on daily basis at the end of the shift, weekly basis on the last working day of the week, which is before the weekly holiday, on a fortnightly basis before the end of the second day after the end of the fortnight, on a monthly basis before the expiry of the 7th day of the succeeding month. So that's the time limit for payment of wages as mentioned under section 17. The deduction of wages, which was earlier the concept captured under Payment of Wages Act, the code says that wages are subject to deductions, which we'll be discussing in the next slide, for any legally constituted social security fund, including Provident Fund, pension or health insurance fund. However, it is very important to note, just like the basic, which is your basic pay, DA and retention cannot be less than 50%. Again, your total deductions should be less than 50% of the total wages. Where the total deductions exceed 50% of the wages of an employee, the excess shall be carried forward and recovered from the wages of the succeeding wage period in installments so that the recovery in any month shall not exceed 50% of the wages of the employee in that particular month. So this is the new provision that has been introduced in the codes. What are the permissible deductions from wages? As mentioned under section 18(2), it can be fines from imposed on the employee for the absence of duty, deduction for loss of or damage to the goods of the entrusted to the employee, for any house accommodation, for amenities or services provided by the employer, for recovery of any advances made by the employer to the employee, for repayment of prescribed labor welfare fund loans, deduction for improving housing or other government sanctioned loans, statutory deduction like income tax or other government levies. It can also be deductions for contribution to social security schemes like PF, pension, insurances, for payments to cooperative societies, for the trade union membership fees, range-specific deductions for losses due to counterfeit currency or failure to invoice, bill, and incorrect rebates. Deduction authorized in writing for contribution to the Prime Minister's National Relief Fund. So these are the permissible deductions which are there from the wages. Besides these, no other deductions can be made from the wages. The concept of payment of bonus. There is no change in the provisions relating to bonus. Everything is same, which was earlier mentioned in the Payment of Bonus Act, and the related conditions continue to remain in phase, remain the same under the Code on Wages also. Like mentioned earlier, every employee who has worked at least 30 days in an accounting year is eligible for bonus. A minimum bonus of 8.33% or 100 rupees, whichever is higher, is payable. Where allocable surplus exists, bonus may go up to a maximum of 20% of the wages. For employees who are earning above the notified wage limit, bonus is calculated on the notified wage or the applicable minimum wage, whichever is higher. Any bonus beyond the statutory minimum linked to the productivity is payable only under an agreement settlement, and total bonus cannot exceed 20% of the wages. This was the concept of bonus, as same as the earlier Payment of Bonus Act. Records, returns, and notices. So now, laws are not static. Earlier, the compliances were confined to only files and registers. Now, with the change in society, with the technological advancement, even the law has become technology-driven. Employers must maintain prescribed registers, records of employees, and attendance, wages, reductions. All of these should be maintained, but must be kept in an electronic form as per the rules. Display of notices. Employees must display key details such as abstract of the code, wage rates, wage periods, and jurisdictional inspector-cum-facilitator at a conspicuous place. Wage slips must be issued to the employees as per Form 5, containing wage and deduction details. Employees must maintain and submit prescribed returns and documentation to demonstrate compliance under the code.
Yeah, Surabhi, the presentation is going great and it's very interesting. I see a lot of questions coming from the audience, and thank you, audience, and keep putting in your questions. They are very interesting and practical. So, Surabhi, if you may just try and wrap up in the next 10 minutes so that we can spend sufficient time for the Q&A as well. Yeah.
Sure, Dr. Samir, I'll do that.
10 to 15 minutes max.
Sure. So, registered under the Code on Wages. Employees covered under the code shall maintain the prescribed registers under Section 51, either electronic or in physical form. As per the central rules, the required registers are employee register in Form 1, register of wages for deductions for damage and losses in Form 4, attendance register cum master roll in Form 9. All such registers must be maintained in the prescribed forms as are provided under the rules. Advisory board is the board that is constituted by the central and the state government, where up to 1/3 of the members may be independent members. At least 1/3 of the members must be women. And the chairperson is appointed from among the independent members. The functions of the advisory board would be to advise on the fixation of minimum wages, to recommend revision to the minimum wage rates, to promote employment opportunities for women, and the central board may advise the central government on issuing directions to the state government. That is also a function of the advisory. Inspector-cum-facilitator is an authority which is decided by the appropriate government. The central or the state government may appoint the inspector-cum-facilitators who will prescribe inspection schemes, including web-based and randomized inspections, perform a dual role as a compliance facilitator. They are deemed as public servants under the law, and the employers are legally required to furnish information as and when requested by the facilitator. All searches and seizures will be as per the Code of Criminal Procedure. This inspector-cum-facilitator has the power and the function of advising employers and workers on compliance with the code. They will inspect the establishments and examine workers. They can also seek information and verify compliance with the statutory requirements. They report legal gaps, defects, abuses, search and inspect the establishments, seize or even take copies of registers, wage records, notices, exercise additional powers as may be prescribed under the code. Now, the very important concept is opportunity for compliance. So the code not just impose penalties, it promotes correction as well. This opportunity for compliance is an opportunity given by the inspector to the employers. Let's imagine an employer forgets to file a return or a register. So instead of prosecuting the employer, the inspector will have the right, the code, to give an opportunity for compliance to the employer. So the code adopts a compliance-oriented approach before initiating prosecution for certain offences. In such case, the inspector-cum-facilitator is required to issue a written direction to the employer, granting a specified period to rectify the violations and comply with the provisions of the code. So now, unlike previous acts, the inspector will not be imposing fines on the employer straight away. In certain cases, it may provide an opportunity for compliance to the employers as well. This opportunity is not available where the employer repeats the same type of violation within a period of 5 years from the date of first offense. So repeated offenders will not be given this opportunity to comply. In such cases of repeated non-compliances, prosecution is initiated directly in accordance with the provisions of the code. So there is no chance for the repeated offenders to get an opportunity. After understanding the key provisions of the code, the obvious question would be, what if the employers don't comply with these provisions? So the code has mentioned 5 contraventions, and the 5 provisions which, if not followed, will lead to certain penalties, like payment of wages if that is less than the amount which is due under the code. If the employers do not follow 50% of wage rule, fine up to 50,000 will be imposed. In case there is repeated underpayment of wages. So because this concept of 50% wages rule is so important, that there are 2 penalties for these. There is repeated underpayment of wages within 5 years of previous conviction, then there can be imprisonment up to 3 months or a fine up to 1 lakh or both. These are the penal provisions for underpayment of wages. For non-maintenance or improper maintenance of records, there can be a fine up to 10,000. For repeated contravention or other provisions within 5 years of previous conviction, imprisonment up to 1 month or fine up to 40,000 or both. Contravention of any other provision of the code, rules or orders issued thereunder, there's a fine up to 10,000. So the highest imprisonment and the fine that we observe is in case there is payment of wages less than the amount which is there under the code. With that, there are certain implementation challenges which HR professionals and their employers would be facing, which includes restructuring existing salary and compensation packages to align them with the revised definition. It also includes increased payroll cost because of the revised wage definition. Broader wage components and benefits may increase overall payroll expenses, so that is an implementation challenge. You will have to update payroll, HRMS, and compliance systems, managing compliance across multiple states with varying wage rates, because every state will have the right to have a minimum wage which is more than the floor wage. Every state might have different wage rate. So the employers who have their establishment based pan-India, they will have to ensure that they maintain a track of the same, and multiple states have different rates applicable on its employees. They'll have to train HRs and payroll teams on the new requirements. They'll have to monitor contractor and outsourced workforce compliance. This will ensure contractors and vendors comply with the code and wage requirements. The other challenge is handling employee concern arising from the compensation changes. Now, because employees are getting compensation in a particular structure, if there is wage restructuring, employers might also not understand what is the reason why such wage restructuring is happening. So employers will have to ensure that their employees are able to understand why such changes. So we'll have to do a proactive planning, technology enablement, and continuous monitoring are the key to successful implementation. What are the best practices for organizational preparedness and transition planning? It is important for us to ensure as employers that payment of minimum wages and timely disbursement of salaries, including overtime wages, are as per the prescribed rates, uniform definition of wages for all kinds of statutory calculations, and to ensure that the same is complied with bonus and equal remuneration provisions. We will have to maintain prescribed registers, records, and wage slips, ensuring proper documentation of employee-related wage details. Ensure non-discrimination and statutory compliance in all wage-related matters. It is important to cooperate with the authorities by facilitating inspections, audits, and compliance verifications, where the labor codes and corresponding state rules are already applicable. Employers must undertake immediate and comprehensive compliance alignment, covering their employment agreements, HR policies, wage structures, and social security contributions. Where the rules are yet to be notified, they should still implement all clear and substantive provisions of the codes that do not depend on the space-specific provisions. So certain procedures or certain provisions which are there as per the code itself, and there is no need for state-specific clarifications, those should be implemented without any delay. With this, Dr. Sumit, we come to an end of the presentation, and we can take the question and answers now.
Yes, Surbi, thank you very much for a wonderful presentation and in time, I would say pretty detailed, pretty exhaustive, quite deep dive into the Code of Wages, and you covered all critical aspects. Of course, these are very detailed, elaborate codes, and not everything can be covered in 1 hour, but I think Surbi, you did quite a good justice to it. But while you can take a voice rest and have a glass of water, the good news for you is there are innumerable questions just pouring in.
That's great.
Even every second the questions are pouring in, and thank you everyone for wonderful attentiveness as well as the question that you are pouring in. I'm sure we will not be able to cover all the questions in the next 30 minutes. However, what we'll request Surbi is to answer as many as Surbi you can. I'll do a rapid fire, and then we can actually compile an FAQ document based on these questions. So people, if we are not able to answer your questions on the webinar, we'll still try to compile the FAQ and share it with everyone, whoever has registered for the webinar. So in the meantime, may I request Complinity team to just play a small 1-minute video on Complinity?
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Yes, thank you.
Welcome to Complinity.
Thank you very much, Complinity. And just to reiterate, Complinity is India's leading compliance software. It's one of the top 3 compliance softwares in the country, adding value to 1,500 plus companies. And it covers all the laws which apply to any company, and labor laws is no exception. So you will have the code on wages, the other 3 labor codes, all the central rules, state rules, as and when they are notified, all will be part of the Complinity compliance software. And software as a service, you can get all these legal updates, notifications, circulars, and compliance checklists in Complinity. So I'll just do a short poll. If you represent a listed company or an MNC or a funded company or a company with turnover of 100 crores and would like to have a demo of the Complinity compliance software for your organization, if you can just indicate here, yes, no, maybe. If you indicate yes, my team will be calling you after the webinar in the next few days to know your requirements and give you a demonstration of Complinity. So take 30 seconds, and if you can indicate your interest. But people who are saying yes to the first question, it'll be good if you fall in any of these criteria, then only say yes, because Complinity works best for these kind of organizations. Either you're a listed company or an MNC or a funded company, private equity or venture, or a turnover of more than 100 crore. You could be a manufacturing organization, you could be a service organization, you could be any industry. Complinity works for food industry, for hospitality, healthcare, auto industry, BFSI industry, etc., etc. So answer yes if you fall in any of those criteria. And second is, if you would like to get an advisory on labor codes implementation for your organization, please indicate your preference, and the team of experts here will reach out to you and see exactly what you need in terms of either opinion or implementation help, etc. So while I'll leave this open for some time for you to fill up. In the meantime, Surbi, are you ready for the Q&A?
Yes, Dr. Sumit.
Okay. So I understand that certain questions may not be on code on wages. They may be outside the code on wages. They may be on other code, etc. So if you feel any of the question is in those codes, you may skip it or you may mention it that way. And if you would still like to answer it briefly, you can do that, because anyways we'll be doing more webinars on the other codes, right? And so here I go, and I'll be very fast now. So
Sure.
question by Mr. Thankapan. There seems to be a mismatch between the 50% basic and minimum basic for PF applicability in cases of total salary less than 30,000. Could you enlighten us?
So I think that's related to the PF contribution. So in this case, ESIC will be applicable.
What will be applicable?
ESIC, Employment State Insurance Corporation, that will be applicable who is making schemes for the PF. So that will be applicable, not the codes.
Uh-huh. No, the question is there seems to be a mismatch between the 50% basic and minimum basic for PF applicability. So
Yeah,
they're
so
talking of
PF
ESIC.
applicability. Yeah, so
They're talking
PF
of ESI, they're
applicability.
talking of PF here.
Yeah. So PF applicability, as mentioned in the ESIC, would be applicable, not on the code on wages. Also because this will be handled more detailed in the Social Security Code. But the PF applicability, as mentioned, as through the
In the
ESIC
PF
would be
regulations also, not ESI, the PF
yes.
regulations. I
Yeah.
think you mentioned PF. Okay. Okay, so thanks. What are the salary components that are excluded from wages definition? Example, ESI contribution, year-end incentive, medical insurance premium paid directly by the company. All this will be included or excluded?
So just like I mentioned, only basic DA plus retention allowance will be there included.
Right.
Rest exclusions, including employer contribution to the PF, and all other allowances will be excluded. Those will not form a part of inclusion.
Right. So all these contributions will be excluded. Only the three will be included.
Yes.
Is this started being implemented in Maharashtra, for which the government gazette is pending?
So no, for Maharashtra, the rules are yet to be notified. So you can implement the provisions which are clear in the code, and no state specific requirements are there, or no state specific rules are required. You can implement those provisions in the establishment.
What if we don't restructure blue collar employee salary having basic salary above 50%, continuing with existing salary component, which is specifically not an exclusion as per wage definition?
So, just like I mentioned, employee includes everybody, including an unskilled person or a skilled person. So, you will have to ensure that the 50% wage rule is followed even for the blue collar employees. Otherwise, penal provisions will be there.
Yeah.
So, you'll have to follow.
Yeah, and but Yashoda, what you mentioned is that if the basic salary is above 50%, so if it is above 50%, anyways you are compliant.
That's right.
The law says it should not be below 50%, and you're anyways above, so no need of restructuring there, right, Surbi?
Yeah, that's right.
Pratik says, I understand that till date, no corporation is notified under Section 5 of Code on Social Security. I think we'll skip this question because we are on Code on Wages, so Social Security will handle in the upcoming webinars. ESI also, as such, PF, ESI, there are special acts for that. So ESI, there's an ESI Act, and it is not being replaced by the ESI is not replaced by the Code on Social Security, right, Survey?
Yeah, that's right.
Yeah. So those, so as per the ESI Act, ESI liabilities, Pratik, whatever are the queries, they will continue to be governed by those respective acts. And one, they're not covered under Code on Wages, and they are not even getting replaced by the Code on Social Security. So I'll skip the ESI question for now. Reimbursement based payments like fuel expenses, are they covered under the wage definition and subject to PF gratuity?
So the reimbursements are not covered. The exclusions specifically talks about the allowances only. Reimbursements are just the expenses incurred by the employee, which is then cleared by the employer. So it has nothing to do with the inclusions and the exclusions. For those, the wages definition is not applicable. Those are neither included in the exclusions, not excluded from the exclusions.
Okay, Dharmesh says, as per Section 6, till the time all rules are announced, old rules will apply. Does that mean that the code is yet not in effect?
No, that's not correct. Just like I mentioned, for the states where the rules are not yet enforced, the provisions which are there in the code, which require no state-specific directions, that can be made applicable.
Yeah. So something where the rules are not required means whatever is mentioned in the code and has already been notified, that is applicable. However, if your state's rules have not been notified, then of course those rules are not applicable, right? But then the old rules, old regime will prevail to that extent. Surabhi, is that so?
Yes. Yeah, that's right. Yes.
Yeah. For example, the returns, the forms, and all other things are
Yeah.
still in the old one until the new state
Yes.
rules are notified. Yeah.
Because the rules are the one that would be clarifying on the registers and returns. So
Yeah.
we'll have to follow the previous acts in that case.
Yes, till the time they are notified.
Yeah.
Okay. If basic DA retaining allowance exceeds 50%, say for example 65%, then can we restructure by reducing the same?
Yes. So basic DA retaining allowance, if it exceeds 50%, then you're already compliant with the
So the
provision.
question, Surabhi, the question is, can we restructure by reducing the same to 50%?
Yes, we can do that because ultimately we have to comply with the 50% wage rule. If you're already above that, you can be there till 50% and you'll be complying with the same.
Yeah, no, the question is not, I mean, of course they are compliant at 65%, but then the question is, the law says it has to be minimum 50. They are already at 65. Now they want to reduce it to 50. So in my opinion, yes, I think you can restructure it to reduce it to 50%. Yes.
Yes, yes, that's right. That was what I was also mentioning.
Yeah. Implementation notification came on 8th May. Does this mean it is applicable from 8th May or retrospectively from 15th November?
So not retrospectively, it is applicable from 8th of May.
Yeah. Mahima says, should reimbursements paid to employees be considered part of the total remuneration? So the answer is no, right? Reimbursements are not part of the total remuneration, but not part of the included portion of minimum 50%.
Yes, neither the included nor the excluded.
No, when you say not neither included nor excluded means what?
So, so that if you would encourage the fact the wages is divided into inclusions and exclusions. Inclusions has to be at least 50%. Now
Yeah.
we cannot include reimbursements in the exclusions part also because the minute we included in the exclusions, we'll have to then revise basic accordingly. Reimbursements are not covered in the definition of wages only because that's the reimbursement an employee is getting for the amount that he has already spent. So
Right.
it is not included, not even excluded. It is not applicable for the definition of wages. It can be a part of your salary structure, but not for the purpose of 50% basic.
Understand. Okay, treatment of an allowance by different name, example, special allowance, which is not specifically covered in the definition of excluded allowances with HRA, etc. What is the treatment?
So special allowance is already there in the exclusions, and any kind of allowance which is there, it is a part of exclusion.
Right. Definition of a worker, Mr. Shankar says, is the rupees 18,000 or more per month applicable to all? So if we are paying rupees 17,000 per month to a worker, then it is outside the purview of the code. Please clarify.
So it is only with respect to the worker, it is outside the purview of the code and not for the employee, because then in that case, he'll be a supervisor. He'll be then not a supervisor and he would be then outside the code.
No, if the definition of worker is that
Supervisor,
in the supervisory capacity, they should not be earning more than 18,000. So if it is more than 18,000, it will be outside. But if it is less than 18,000, it will be in the purview,
then it will
not
be
outside
covered in the definition of
of a worker. Yes.
Yes, yes, yes.
Retention allowance is wide definition. How do we identify retention? I think it's not a clear question. Do you understand?
Yes.
No, not a
No, how do we identify?
Okay, we'll skip this. Do wages include basic pay plus DA plus retaining allowance, and must these exceed 50% of CTC, or are other allowances capped at 50%? I think we've answered that. Basic plus DA plus retaining minimum should be 50%, and everything else should be less than 50%, right?
Yes, that's right.
Okay. FNF to be paid within 2 days of separation. Does this mean from the date of resignation or date of relieving from the duties? I think it's date of relieving only, not resignation.
Yes,
In resignation,
from
there'll
the
be
date of
periods
relieving.
also. Resignation, there'll be say 30 days, 60 day notice of resignation. So it's from the relieving. But I think as Surbi clarified, the respective state Shops and Establishment Act can prescribe higher notice FNF
Kind of.
compliance, and it is 30 days as per Punjab and Haryana Shops and Establishment Act, right, Survey?
Yes, that's right. Yeah.
Yes. So in that case, the code very clearly says if a separate act provides for a higher number, then those provisions will also apply. Okay. There are certain repetitions on the 50% rule, so I'll skip those. In wages, food coupon, gift coupon, are they also included? Like historically, people have been taking food coupons or Sodexo coupons and those kind of things.
No, those are not covered.
Yeah, so I think 50% is very clear. Those three components only are there.
Yeah.
Okay. Is yearly performance link incentive, Sanjeev says, yearly performance link incentive also part of wages?
No. So just like I mentioned, only the statutory bonus, as per the codes or the Payment of Bonus Act, is there in the exclusions. Performance linked incentive are not a part of wages.
Yeah. Overtime allowance. What about actual overtime paid, which is not fixed but variable depending upon the workload? Or does this include a fixed overtime allowance paid for a permanent shift timing like 12 hours work, etc. on the overtime?
Please repeat the question once.
Overtime says it's a variable overtime depending on the hours worked. Will it be like part of wages or not?
So variable overtime allowance will be a part of the wages in the exclusions part. You will have to calculate how much will be there every month. So that will be forming a part of exclusion. Overtime allowance is there.
Yeah, but I think the question will come is that since it's variable, how do you calculate the 50%? Because that remains to be seen. If overtime is of course depending on the number of hours worked and all that, it's not fixed, it's variable.
Yeah, because that's variable. Maybe a set pattern will have to be followed. Maybe for 6 months, we can figure out if a person is regularly doing overtime. Then, in such case, at least a buffer should be maintained so that at the end, wages are 50%. Even if the bonus is 5% above that or less that, we should have buffer instead of 50%, we can keep it 55% so that overtime is also covered somehow. And that
Yeah.
50% wage rule is
Or maybe let's see the
satisfied.
rules provide more clarity on the overtime also. Okay, what is the difference between worker, which is earning less than 18,000 rupees, and supervisory?
So supervisor is who is any person who is a supervisor and is earning more than 18,000 rupees is not considered as a worker. He'll be then an employee. Earning less than 18,000 will be a worker.
Yeah, but if somebody is earning more than 18,000 but is not supervisory, will that still be a worker?
Earning more than
the
18,000.
worker definition excludes supervisory and earning more than 18,000. He's not a worker. But if he's earning more than 18K and
And
not
is not a supervisory, then a worker. Yes.
then is a worker.
Yes. Yes.
Okay. So 18,000 is only for supervisory as a limit, right?
Yes. Yes. Yes.
Will gratuity be included for the purpose of calculating the 50% cap on CTC?
No. So gratuity and the retrenchment compensation mentioned at the end, those will not be covered in the exclusions. Only A to I would be covered as mentioned in the section for the purpose of 50% calculation.
Okay. What is the threshold maximum wage for bonus eligibility? So is this 8.33% of minimum wage? So bonus remains same actually. Bonus, no provisions are changing. So bonus remains at 8.33% of the wages, going up to 20% of the wages based on allocable surplus. And the wages would be the same basic plus DA plus retaining allowance, right? Whatever is the
Yes.
definition of wages, which is minimum 50% of the overall thing in those three components, that is the wage, and bonus will be 8.33 to 20% depending on the allocable surplus, and all the old rules of Payment of Bonus Act will apply, right, Survey?
Yeah, that's right. Yes.
Right. Restructuring salary structure, basic is 50% gross or 50% total CTC. your PPT says 50% of gross oblique CTC. And the question, although is not very clear, question is
Yeah.
not very clear, but maybe you can re-articulate since it's the heart of the whole thing. So if you can re-articulate the 50% rule.
So the total remuneration that has inclusions and exclusions, wages is the only part of inclusions. So your wages is A part, that is the inclusions, basic DA retention allowance. B part is the exclusions, allowances. Now basic plus allowances forms the remuneration. So the total remuneration, just the example also that I gave, if the remuneration is 1 lakh rupees, basic should be 50,000 at least, and the rest would be allowances. So that's how I mentioned CTC and basic in the slide.
Right. Now there's something called again special allowance. Can special allowance be still kept an allowance as part of the wage slip as exclusion if the basic wages are more than 50% inclusions?
Yes, that can be retained.
Yeah, if your basic plus DA plus retaining, and suppose you do not have retaining, so it's basic plus DA, and suppose you do not have DA, then it's only basic. So if it's only basic,
Yes.
because if those heads are like no more relevant in the modern MNC or other private context, then you have basic and all other things. So I think basic has to be 50% of the total CTC. That's what you have to remember, right, Survey?
Correct. Yeah, that's right.
Yeah. So somebody says if 100 rupees CTC, then basic is 50 or 59, please clarify. It's 50 only. That's what I just said. Yes. Okay. Do we need to make leave and gratuity provision on behalf of contractor? Poonam says.
So leave and gratuity would be covered in detail in the other codes. So
Right.
at the moment, because would
Yeah.
defer to us.
Yeah, and based on my prior knowledge, I would say that a contractor has to make his own provisions. You are a principal employer, and those things remain same. Means somebody who's a contract employee, a contractor is the employer, and you are a ultimate principal employer. So ultimately, okay, if he does not make the payment of wages, then it's your liability. But then primary liability is of the contractor. So it is the contractor who should make those provisions and not the principal employer in the first place. That's as per the prior knowledge. But although these will be dealt with in the Code on Social Security separately. Is the salary disbursal date 7th statutory of every month for employees below 1,000 and 10th has been changed? Because earlier it was 7th for less than 1,000 and if it was more than 1,000 employees, then 10th of every month. So is it 7th in all cases now?
Yes, it is 7th in all cases now.
Right. So there are certain questions on ESI which we'll skip for the time being because again there are separate acts, separate things. Right now we're only answering code on wages and we'll focus on code on wages. Coupons, meal coupons, car lease, etc. all will be exclusions, not inclusions in the 50%.
No. It will not be exclusions also.
Okay.
The definition of wages will not be applicable. Those will not be considered for the purpose of 50% basic rule.
Okay, so car lease and all, they'll neither be inclusion nor be exclusion, you're saying.
Yes.
Because in the wage definition, even exclusions are also defined that those
Yes.
limited points are the exclusions and the other ones are inclusions. So something could be neither inclusion nor exclusion. It's
Yes,
completely
that's
outside,
right.
not even considered as wage. Neither inclusion nor exclusion. Okay. Okay. The penalty for lower payment of wages than prescribed wages, which is 50,000, will 50,000 be per employee or per month? It can't be per employee. It is it remains to be seen again. What do the rules say? What do the states say? Repeated offense, not repeated offense. But then, but it can't be like you can get away with paying 50,000 and and then not pay minimum wages to everyone. It can't be that also. I think all these things will get more clarity in the rules and all. Yeah.
Yeah.
A startup which has a small company and has only 8 workers is outside the purview of the PF Act but has to comply with the Code on Wages. Is this correct? Yeah, so PF Act requires you to have 20, but then Code on Wages is applicable if it's one or more employees. So
Yes,
Code on
that's
Wages
right.
is applicable, so therefore minimum wages, payment of wages, all those things have to
Everything.
be complied with, irrespective of startup with 8 people. Yeah. Okay, there are a few repetitions on again inclusions, exclusions, few things on ESI. Yes, I am skipping for the time being. Special allowances, we have already covered. Okay, one interesting different question. It says, currently minimum wages are getting revised twice in a year. Will it continue?
It might, because the government says the maximum time period within which it will be revised will be 5 years. So it depends on the state, either every year or twice in 1 year. That depends on the state.
Right. But this time, the concept of floor wages, as you were saying, is also there. So the central government will notify a floor wage, and state governments have to follow that their minimum wages have to be above the floor wages, right?
Yes, yes. And that minimum wages, they can keep on revising till 5 years of period. After 5 years, that's the maximum time within which they may revise the minimum wage.
Right. Okay. Ram Gopal says, what could be the recommended SOP or actions for fixation of wage period? What will be the possible impact in appointment letter or labor contracts? Yeah.
So when you have to fix the wage period, you will have to see if you are making that within 7 days from the date of your last cycle. You will have to revise the appointment letters in case you're making the payment after 7th. And the policies also, you have to ensure that the payment is done by 7th of every month.
Yeah, 7th is in case the wage period is monthly basis. In case the wage
Yes.
period is a different one, it is a
Yeah.
fortnightly, then I think it's 2 days in case of fortnightly.
Yes.
If it is weekly, then I think it's end of the week.
For
So
the end of, yes,
yes, so
weekend.
wage periods are also separate. You can define it, although historically monthly have been the most prevalent wage periods. But yes, you can have different wage periods, and you can define those. Yes. Okay, for the gratuity payable, what is the minimum work tenure? 6 months, 12 months, or earlier it was 5 years. So is there any change in gratuity?
So this is something will be taken care in the social security, but 1 year is the time, which is there.
Yeah, so earlier it was 5 years. So now
But
after
now
1 year,
fixed term.
pro rata you have to provide for
Yes,
gratuity, and that's
this
one of
is
the
for the
major.
fixed term contracts. So
Yeah.
even if you have an employee who is there for a contractual period, after 1 year, he or she is entitled to receive gratuity.
Right, but in case it's a permanent employee, not a fixed term or a contractual or anything, still after
Then
1 year it will be applicable, right?
it will be applicable, but he will be entitled to receive after 5 years.
No, if somebody if a permanent employee is leaving after 1 year, although it will be dealt in code on social security, I understand. But if you have any answers, Survey, right now, that if a permanent employee is leaving after 1 year, then will the gratuity be payable there and then or not?
No, no. It will be payable after 5 years because he's a permanent employee, not a fixed term contract. This provision is only for the fixed term contracts.
I think we should look at it again, because isn't it then more favorable for fixed term? Means a fixed term employee leaving after 1 year, he gets a gratuity, and a permanent employee leaving after 2 years, he doesn't get a gratuity. So it looks unfair.
Maybe that's something we can
look at it again.
discuss.
Okay, in the social security. Okay.
Yes, yes.
Hmm. Okay, for now I understand. I'll focus my questions only on the code of wages. Yes. How the principal employer is responsible under the code on wages?
So he is just like earlier, he's still responsible in case the payment is not made by the contractor. He is ultimately responsible for the same. There is no change in the responsibility of the principal.
Right. And if an employer is deducting late coming charges or a fine or penalty, then is it allowed? And if we need to deduct, then what name can we show in the salary slip for those deductions?
In case of late coming, it is actually maybe absence from duty. So it might be considered as a deduction because if you're coming late to the office, you're absent from your total 8 hours of period and you can deduct that amount as deductions.
Okay. Is this law applicable in Delhi or still under consideration?
So Delhi, the rules are not yet out.
Right. I think except West Bengal, either those 3, 4, 5 states, the rules are already notified. Arunachal Pradesh, Sikkim, which are the other states? So do you remember?
Arunachal Pradesh, Sikkim, Punjab, Himachal, and there was one more state, I think, Gujarat.
Gujarat. There the rules have been notified. All other
Yes.
states, the draft rules have been published. And only West Bengal, neither they
Yes.
have been notified nor any draft rules have been published. Okay.
Yes.
Okay, we are already at 1:28 p.m. I'm conscious of everyone's time, and as I said in the beginning, that of course we can't answer all the questions. There are hundreds of questions. So, but what we'll do is these questions are very good because they give us an input, and yeah, Surbi and team of lawyers at eMinds Legal, I'll request them to, if you can compile these questions and make a document and maybe share it with the registration registrants of the webinar. It'll really add value to them. So
Sure.
yeah, and anything else, Surbi, you'd like to share as a parting, as a closing note on the code on wages?
I would say now, since the code on wages are already implemented, barring the state rules which are there, employers must act upon it, and they should start restructuring of their internal policies, including the salary slips, so that they are not later on penalized by the authorities. It is high time now that we start acting on the codes.
Yeah, so the code on wages is there, and gradually states are releasing the state rules in your respective states. The draft rules are already there, so you can start working on implementation of the labor codes, not just code on wages, but all the codes. It is high time. It is good time, and so recording of this webinar will be available on these links. The links are already there in the chat box. Complinity on YouTube, Complinity on LinkedIn. You can also request a demo. The demo links are also there. Just register your name, number, etc., and my team can reach out to you. As you know, Complinity will have all the checklist of all the labor codes, including code on wages and the state rules and the central rules and the notification circulars as and when they come within 48 hours of their getting released. So it's a great compliance software to help you comply with the labor laws and all other laws applicable to your company. And also, please connect with me on my LinkedIn. I'm very active on LinkedIn, and not only I publish these webinars and recordings, etc., but also keep writing about emotional intelligence and leadership and all that. So happy to be connected on LinkedIn. And thank you, Surbi, for sharing your detailed presentation on code on wages, for answering so many questions. While I also, I may have asked you several questions, and I also understand it's a new area. It's an area which everyone is reading. Everyone is sort of trying to make sense out of it. The final rules are not yet out in many states, and many questions may still not have the correct or the clear answers today. But as we go along, we'll surely get all the answers, and people will be organizing webinars on other three codes also gradually and bring in experts. So thank you very much for attending in huge numbers today. And thank you, Surbi, for the presentation and your time. Thank you.
Thank you, Dr. Sandhan. Thank you, everyone.
Yeah, thank you. Bye. Thank you, Complinity, for organizing this, my team, Nandita and Vikrant, and for the videos and the logistics and the tech and the mailers and all that. Thank you very much. Bye.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.